So I show on my clock over here that it's 3 p.m. Eastern. So just to be respectful of everyone's time, we're going to go ahead and get started here. So thanks so much for joining us for our Ask Me Anything About IP session today. My name is Leah Loch. I'm the Director of Marketing Communications for NACCE, and I'll also be serving as the moderator for this webinar. So if you have any questions, need any technical assistance, please feel free to write to me in the chat and I'm happy to help. Alrighty, so just a few things here that I wanted to go over, what I like to call my housekeeping rules. So number one is that we are recording this session, so you will receive the slides in the recording in about 24 hours from now. That will be an automatic email that you'll receive from Zoom, so be on the lookout for that. And then two, since this is an Ask Me Anything session, we highly encourage you guys to enter in your questions in the Q&A feature on your Zoom dashboard. You can put them in the chat, but it's just a little bit easier for us to monitor them if you put it in the Q&A feature. You can continue to use that chat to correspond with one another, respond to the speakers, add in your own comments, links, etc. And then lastly, if you are on Twitter, we always encourage folks to share their insights with us using the hashtag NACCE member webinar and tagging NACCE. We love to hear your takeaways. Alrighty, so just a little summary of what we're going to be talking about today. Obviously, all things IP. So, you know, a couple of those frequently asked questions that we hear a lot are, how do I know if I have something worth patenting? Do I own my IP if it's developed on campus? When is the best time to register a trademark? We so appreciate everyone that entered in some of their own questions here. And like I said, we'll be giving lots of time for folks to enter in their questions live as well too. So don't be shy and feel free to enter those at any time. So without further ado, I wanted to introduce Jelani Adlam, who is the program manager for the Michelson Institute for IP. She will also be moderating this webinar as well too. I've had the pleasure of working with Jelani and her team over at the Michelson Foundation, and so it's just a pleasure to be co-presenting this webinar with you. So Jelani, I'll turn it over to you.
Okay, thanks Leah for the introduction, and thank you everyone for joining us on the line today for this IP learning community and this Ask Me Anything session. We're really pleased to have two incredible speakers with us that are here to answer your questions, and I will introduce them now. So first up, we have Phyllis Turner-Brim. Phyllis is Deputy General Counsel and the Chief IP Counsel at HP Inc. And prior to that, she was the VP and Assistant General Counsel at Starbucks. So welcome, Phyllis, and I'll give you a moment to introduce yourself in whatever way you'd like.
First of all, I want to make sure everybody can hear me. I think they can.
Yes.
I don't have much more to say, just that thrilled to be here. Love anything related to education. It's my passion, especially around intellectual property. And I've been practicing IP law now for almost 30 years. And before that, however, I was an engineer. So I worked in product development and lots of other engineering focused ways before attending law school. So I'm thrilled. I'm passionate about IP. So I'm just thrilled to be here. Thanks.
Awesome, thank you, Phyllis. And then next I'll introduce Jason Lott, who is the Attorney Advisor for Trademarks Customer Outreach at the U.S. Patent and Trademark Office. And Jason, I'll also give you a moment to just introduce yourself in whatever way you'd like.
Sure. Well, thank you very much for the invitation. Very happy to be here. So I'm the Attorney Advisor for Trademarks Customer Outreach, which is basically a long way of saying that it is my job to teach folks about trademarks, what they are, why they're important, and how a federal trademark registration can help you grow your business. I've been working for the office for almost 20 years. I originally started off as a trademark examining attorney. So I was one of the folks that when you submitted your application, I was one of the people looking it over saying yes or no, whether you could have the registration. And then about 8-9 years ago, something like that, I started moving into doing more outreach because like Phyllis, I love the educational aspect of this. And I want to make sure that you know what you're talking about so you can protect yourself and protect your brand. And so I get excited about doing that. And so I'm very happy to be here and answer any questions that you guys throw at me.
Great, thank you, Jason. I'm going to start pitching questions soon, but quickly I wanted to remind everyone that we are doing a mini raffle at the end of this session. So we have 2 $15 Visa gift cards. Stay on till the end and see if we call your name. So without further ado, our first question here, and please continue to submit questions in the Q&A feature, and we'll get to the ones that are submitted live as well as what was submitted when you registered. The first one here is, what should an artist consider when they're creating a commercial web page with their art? So they're going to be promoting their art on the internet. What are some things you think they should consider?
I guess I'll just jump in. This is not, by far, not my deepest level of expertise, so I know just enough to be dangerous. We definitely include, if you're going to, you're including images of your artwork, put watermarks and things that will prevent if someone were to take it, copy it, or something like that, that they would have that property of, or some sort of watermark across it, that you might have to invest in a little security technology for your website. But obviously the web is the way you have to, you have to do it. So it's not like, oh, just don't do that and you'll be able to protect all that. That would be my advice.
Yeah, that's great. I'll tag team on that. So again, all of this is not necessarily my area of expertise either, and again, not legal advice. But one thing you might want to think about if you do have artwork is you might want to think about registering copyright for your pieces of art. And that's actually a pretty simple process you do through the Copyright Office. It's copyright.gov. And you can submit an application. I forget exactly what it is, either 35 or 55 bucks, something along those lines. So you might want to get a federal registration of the copyright in your work. That would be a good thing to have. I might also think about what is the sort of brand name that you use to market your artwork. So maybe it's your name, or maybe it's the name of your gallery that you sort of created, or maybe it's like just a really cool name that you use as the domain name, or as part of the domain name for your website. So that would be something that you might want to protect via trademark registration at our office. Mm-hmm. And so there would be different ways of obviously going about that, but that would be another thing that I would think about is, what is it that people, because what a trademark really is, it's an indicator of source. It's how people find you in the marketplace. So if people find you by your name and they know every time I see Phyllis Turner-Brim, I know that it's going to be this amazing piece of art. Well, then it might be something that, that's an indicator of source. And so Phyllis might want to, register that as a trademark for her artwork. So that would be something to think about. Think about your artist name or your gallery name or something along those lines. And I can dig a little bit deeper into domain names and trademarks a little later on if you guys want to hear more about that. But those are some of the original things I would think about anyway, if I were going to set up a website to sell my artwork online.
Okay, I think I have the next question. Are there sources of funding for students to experience patent submissions? So maybe Phyllis, I'll start with you and then we can go to Jason after.
I don't know about sources of funds, but here's what I do know. That the USPTO has a pro bono office where lots of lawyers such as myself, patent lawyers who are registered to practice there, sign up to work, to do pro bono work to support small inventors or folks with limited funds for various reasons. That's always a great place to start. I will also say there's a number of schools, like for example, I believe still John Marshall in Chicago, who have clinics for, again, in a pro bono sort of way to help new inventors or folks just getting started to understand the patent process. I would also just highly encourage visiting the website of the USPTO. there are resources there up, down, and across. And I think a lot of times I have people when I was in private practice that would pay money for me to answer questions that were clearly, they could have gone just to the USPTO website and gotten their answers. So I would say start there. Start with the free stuff.
She set you up nicely, Jason.
Exactly. Thank you very much, Phyllis. Yeah, USPTO.gov is the website, and it is a great place. There's lots of resources. I'm obviously more familiar with the trademark side than I am the patent side, but what Phyllis said is absolutely true. There are, like a pro bono division. There's also we call them law school clinics. The USPTO has partnered with about 59 different law schools around the country. And sort of what happens is if you meet certain income eligibility requirements and you apply to one of these programs, then you will get paired up with a faculty advisor who is an attorney who knows what she's doing when it comes to trademarks and patents. And you'll also get paired up with a law student who is obviously learning the information, and you will get help with your application for free. So that's obviously a really great benefit. Let me see here. Maybe I'll see if I can throw it in the chat here. I can type in the link. I think we have a short link here for a marketing URL here for this.
All right.
Okay.
And that would be a place that I would look. And again, that's not necessarily funding, but it might be, working with your university. I think there are lots of tech transfer departments and, and things like that, or, at various universities. So it could be that you're able to get funding that way by partnering up in a sort of, private-public partnership, that sort of thing.
Perfect. Thank you so much. I'll turn it back over to Jelani.
Okay, I have one that's interesting. And this is about, I'm going to paraphrase here, but this is about someone who's interested in selling a doll with a celebrity likeness, and they have tried to reach out and they can't get explicit permission for this. So is there a way that they can protect themselves? Is this allowed? It seems like some of the dolls might be political figures as well. So they mentioned Bernie Sanders and Amanda Gorman, Jill Biden. So if they wanted to sell these and the proceeds even go to like a nonprofit source, so it's not for profit, what are some of the restrictions around that?
Wow. Boy, there's a lot there.
Yeah, Phyllis, I'll let you go first on that one.
So just as a general matter, you're not permitted to use people's likenesses without their permission. Let's just start there. Just as a general matter, whether they're a celebrity or not, you have to have a license to do it. Okay. Otherwise, you run into trouble where they'll be able to seize all the materials and lots of others. Can be a lot of ramifications. Now, when it sort of depends also on what kind of figure this is, because as to public figures like a Bernie Sanders or someone like that, if it's something that could be characterized as a parody, then it might be permitted, right, as a parody. But that is a what do I call a legal, that's a judgment call on that piece. But in general, I mean, the way to protect yourself is you have to get a license. I mean, this is becoming more and more and more an issue because of social media and because how quickly people can gin up t-shirts and bobbleheads and masks and all kinds of things nowadays. And everyone has a capability to connect with some individual on Etsy who can make it, tomorrow and send it to you. So, but you have to be very careful because if you are deemed to be using someone's likeness without their authorization, you could lose the whole, all the materials and things, not only the things that you have developed, so the actual mugs or t-shirts and so forth and so forth and so on, but also the things that are used to make those things. So any plates, any stencils, any things of that nature would be seized and destroyed.
Yeah, I would recommend you find an attorney that you trust who can represent you and give you specific legal advice in this case, because that's absolutely true. There is, sometimes referred to as a right of publicity, and folks have that. And so if you are making money based upon someone else's image, that's not exactly right. So be very, very careful when it comes to that. And I would say, yeah, talk to an attorney if that's somebody that that's something that you want to do, and you think, even if it's satire, even if it's parody, something along those lines, you got to be very, very careful, because you don't want to put yourself in a risky position.
Okay, and we had a quick follow-up asking if all the memes of Bernie and like his mittens, are those considered parodies? So
Probably so, or satire. I would say the other thing is there is a connection between making money off of it. So if people are just putting things out to be funny and they're not seeking to leverage that to make any money, specifically on that item, they're selling that meme, they're selling something like that, then the reality is, whether it's an infringement or whatever, in fact, nobody's going to care, because it's funny and it's actually helping sell those T-shirts that Bernie is actually selling to support the poor folks and the people and the homeless shelter. But if you're seeking to make a profit off of somebody else's likeness, that is where we have the issue.
Awesome. Thank you, guys. Very relevant. Good. I'm glad that I think that was Jason that asked that. So thank you for following up with that. Okay, our next question is, do you have advice about the best way to protect software? Is it okay to proceed without a patent? What are the risks in regards to investors in proceeding without one?
You can always proceed without a patent, all right? The question is it wise? Software is an interesting area because, number one, there's all kinds of controversy around what software is protectable and in what way. So there are a number of places, and many that I have, and some of I have worked for, that protect software through copyright, which is one area of protection. There are quote unquote software patents. Those patents usually rely on sort of the output of the software. So what does the software cause to happen versus the software itself? So the copyright protects the software itself, like the code. And the problem you have with that is that an infringement requires a copy. And so these are millions and millions and millions of lines of code. And so frequently being able to detect what is a copy and what is not a copy is a question, because you and I are not interested in the software that runs our machines. We're interested in the output of the software. So what does the software cause to make happen? And that is really the place where people focus their patenting activity. What is the novel, non-obvious, and new thing, right, that is happening as a result of the software being leveraged on a computer? So all software claims and patents have a device on which the software is running, because that's part of the claim.
Thank you. Jason, did you have anything you wanted to add to that?
I do not. I will defer to Phyllis on all things patent related.
Okay, perfect. Thank you so much, Phyllis. Jelani, I'll turn it back to you.
Okay, have something else patent related here, and it's more international in nature. So when a patent has not been applied for in another country and is issued somewhere else, like the US, what, if anything, prevents someone in that other country from making a product to sell because the patent was not applied for there? And why don't more people do that?
So let's start with the beginning. Patents are territorial. So US patent has rights, governs what happens in the United States with some limited exceptions. There are some things that happen outside the United States for which you can sue people for infringement inside the United States. One of those things is importing. So if you're importing something that is patented in the United States, that is an infringement under 35 USC. It is also frequently, depending on the circumstances of the marketplace, actionable before the International Trade Commission. Although if you have an action before the International Trade Commission, the only remedy is to exclude that product from the United States from the United States territory, right? They can't issue or provide damages or anything like that at compensation. You have to go to a federal court for that to happen. So a lot of entities do not file patents in other countries. Sometimes it's a cost prohibitive activity. One of the strategic concerns that any individual would want to take into account when they're seeking to file their patent application is where are they going to operate and where do their competitors that they would want to catch in the act of infringement operate. And I'll just give you a classic example, and that is Singapore. Like, so Singapore is not a large country, so you wouldn't expect a lot of manufacturing, although there is some there. A lot of entities file patents applications and get patents issued in Singapore because it is a port, a very large port country, and so you can catch infringing goods kind of going through Singapore. All right, and it's not an expensive place to file a patent in a patent application. So you may file, if you were in a big international business where there's a lot of trade and you know that a lot of that trade is going by ship, typically through Singapore, you may go ahead and file a patent, a companion patent in Singapore so that you could catch infringers in that circumstance. So it's a strategic concern as to whether you file in other countries. But importing something that is patented in the United States into the United States is an infringement. And so while you could have it made externally, you couldn't bring it to the US and not have potential liability.
Okay, thanks. And Leah, back to you.
All right, awesome. I'm going to go to one of our live questions here. How can startups with limited resources protect their IP rights? Jason, do you maybe want to start with this one?
Yeah, sure. Well, first things first, I mean, one of the things that, Phyllis already mentioned is like pro bono clinic through the USPTO, if you want to protect the patentable things that you're inventing. And if you're a small, startup, and you're probably also going to want to protect your brand name, your slogan, your logo, whatever it is that people use to find you, whether it's online or whether it's in real life, if it's at a farmer's market, whatever it happens to be, whatever it is that people use to identify you as the source of your goods and services, yeah, you're going to want to protect that too. And that would be by registering your trademark, registering your brand, your slogan, your logo, your design, whatever it happens to be, with us, with the United States Patent and Trademark Office. And so we also, as I mentioned, there are the law school clinics, which is sort of a cheaper way, anyway, to get some help with your trademark application. But the cool thing is that if you are willing to do the research on your own and educate yourself about trademarks, you can file your own trademark registration. Of course, that's for people who are domiciled and companies domiciled in the United States. It's a little bit different if you're foreign domiciled. You have to have an attorney licensed in the US, but for anybody watching who happens to be domiciled in the United States, it is something that you can do on your own. So it does take some work. You do have to educate yourself. You're going to be filling out forms. You're going to be communicating with a trademark examining attorney at the USPTO. But there are lots of people. I mean, I forget what the exact percentage is, but there are a lot of folks who file their trademark applications by themselves, and they do perfectly fine. We do often recommend that you do work with an attorney, which is why things like a law school clinic would be very helpful. But it is something that you can do on your own. And all the resources that we have on USPTO.gov, they're all free. So if you're looking for free resources that aren't going to cost you anything, the only thing it's going to cost you is time. So you can use those to help you. And that's from the trademark side anyway.
Okay. So if you're willing to put in the sweat equity, you can do it by yourself.
That's right. That's right. And the good thing, that's absolutely right, Leah. And the other thing too is that if you put in that sweat equity and you're learning all this stuff and you get to a point you're like, oh man, Jason, that guy, he was wrong. This is way too complex. I don't want to deal with it. And then you do decide to hire an experienced trademark attorney to help you. When you go to hire that attorney, you're going to be walking in there with much more knowledge And so you'll be able to tell if that attorney knows what he's talking about. Like, he might not. You might know more about trademarks than that attorney does, right? So when you're going through the hiring process of who it is that you're going to hire to work with you on your trademark, you can come in there already knowing, look, these are the things that I know that are out there. There's this potential, there's this company that's in another state. I think it could be a problem. I would like to have your advice on what to think. Like, these are the 2 trademarks I had been using. This one I can tell is descriptive, so maybe I don't want to try and register that, but I have this really cool one that's a fanciful or an arbitrary mark. Maybe that's what I can see there's more strength in that. I can protect that trademark better. So I think I want to go that way. What do you think? And then you could get opinions from an attorney. So going in with that knowledge is really going to help you if you do decide to hire someone.
Excellent, thank you. And Phyllis, did you have anything you wanted to add to that?
Yeah, I think from a patent perspective, definitely go the pro bono route. You need a lawyer. I'm just going to say that. You need a lawyer to navigate the patent system in the US and around the world. There are, and I would reach out to the, as I said, the USPTO and get some names of folks who are doing the pro bono work, and visit clinics. You can find somebody to at least help you get started, or coach you in the process, because just like you can file your own trademark application, you also can find your own patent application. You do not have to be, I, as a person representing others, have to have a special registration number from the USPTO in order to do that. And I got that number by taking a test, a very hard test, I will say, 30 years ago. But an individual, if you were representing yourself, you do not have to have a registration number, but you might want to coach, right? Somebody who has a registration number who can kind of coach you through the process. And there are ways to, the patent office reduces fees for small entities. There are ways to put off sometimes when you have to pay certain fees and various other things. But I would invest, if your startup is important to you, I would spend some time and invest in getting a lawyer.
Awesome, thank you to you both.
Okay, that feeds well into our next question, which is, when it comes to selecting an attorney to help navigate the patent and protection process, what are some good questions to ask when you're screening, because there are so many attorneys to choose from?
Number one, a question that is regularly asked is like, how many patent applications have you drafted? What is your experience in my technological area? Because most patent attorneys have a technical specialty. So I have a background in chemical engineering, but I actually operate across a broad spectrum of technologies because I've gained that experience over the past 30 years. But initially starting out, I was in what we call the chemical arts. So what is your experience and capability in this art? And references are important. And nowadays, you can find out just about anything you want to find out about people and their background on the internet. And I say spend, an hour going through, doing a Google search and go beyond the first page and go beyond the second page. Go to the Office of Enrollment and Discipline at the United States Patent and Trademark Office has an Office of Enrollment and Discipline where those people who are registered before the office, you can tell if they have a registration number and if they've been disciplined in any way with activities before the office. So I would, from an ethical standpoint, look into that and then interview them and see what the chemistry is, right? Because this is somebody who's theoretically going to be creating the document that codifies the family jewels. And you need to be able to have chemistry and a relationship with them. They need to listen to you. Anybody who says, oh, I've been doing this a long time and I know what to do and you don't need to, and it doesn't spend time answering your questions or asking you questions, run for the hills.
Well, I certainly can't speak to it from the patent side of things, but with regard to if you want to hire someone to help you protect your trademarks, one thing I would say, it's the same sort of analysis. Like, you want to make sure that the person you're working with has lots of experience in the field. Because even though trademarks is not as complex as patents, you don't have to have a special technical background or anything along those lines. It can get kind of tricky, and there are things that you have to get right in your initial application. Yes, your application might get refused anyway, but there are sometimes ways to overcome it. But there are some times when you do something in your initial application that you're not able to overcome. And so that application is going to be refused. You're going to lose all that time, all that money, because your filing fee is not refunded. And all of a sudden you'll be, 5-6 months down the road and you're like, oh man, I just wasted 6 months of my time. I got to start over, right? So you obviously want to make sure that you are working with someone who really knows what they're doing. And one thing I would say is that if you're doing your Google search, your Bing, your Yahoo search, whatever search engine it is that you use, and you're looking at all those things, you're going to come across both law firms that offer trademark services, and you're also going to find what we commonly call the trademark filing companies. And I'm not going to call any of them out, and there are some that do a little bit of both, but you do want to be careful that the company that you're hiring to help you with your trademark is actually a law firm, and there is actually an attorney who's going to be working on your case. Because with some of these filing companies, all they're doing is taking your money to do what you could do on your own. Right? So for a filing company might be like, oh, you want to file a trademark registration? Okay, give us this information. We'll do it for you and we'll charge you X number of dollars. Well, they're filling out a form the same way that you could, right? So if they're not giving you any specific legal advice along with it, it's a question of how much value is being added there. Look, or look, if you want to, if you just want to give them the money and say, just please fill it out. I don't know, USPTO's forms are way too old. I don't understand them. Just do it. Okay, fine. That's cool. But just understand that you're not necessarily purchasing any legal advice for your money. Which is not necessarily a good thing, because you want to make sure before you file that no one else has already applied to register a same or similar trademark for related goods and services. If that's the case, your application is going to be refused. Wouldn't you want to know that before you filed? Well, you can do that search on your own, or you could hire an attorney to do it with you or for you. But a trademark filing company might not necessarily do that. So I would say be very careful that you're sorting out exactly what it is that you're going to get for your money. Are you getting legal advice, or are you just paying somebody to do what you could do on your own? So do your research and make whatever business decision is right for you.
Okay, and some quick follow-ups to that are, what are the filing fees for the things that you've mentioned, and how much on average does it cost to obtain a patent and, let's say, a trademark as well with an attorney involved?
So from a patent perspective, I have to admit that it's been so long since I directly have filed a patent application. I don't know what the filing fee is. I only know this, that the filing fee from a patent perspective is de minimis compared to the amount of money you'll spend with an attorney drafting a patent application, drafting the claims, getting them right, getting any figures or drawings that you need to have done, doing any prior art searching, and getting that package ready to go to the patent office. For typical, I always go high, medium, low, and low would be sort of what we tend to call the simple mechanical device. So think of a tool or something like that, a mechanical tool, or some sort of device having, gears and various things, few gears. That patent application for something like that should be between $3,000 to $5,000 probably for drafting, and then filing fees on top of that. High, I'm just going to go all the way to the other end, would be when you talk about, for example, the COVID vaccines. Those applications probably cost hundreds of thousands of dollars to draft, because it's not just one, it's a series, it's going to be a series. And in order to make sure they get the right protection and they create a thicket, as we call it, around those vaccines, J&J and company are likely to invest thousands of dollars in filing and prosecuting those applications all over the world. And one application that you file and prosecute all over the world of that magnitude ultimately would be wind up in the millions of dollars of fees.
Phyllis, I was going to look up for you what the patent fees are, but
Yeah, what
well,
what
I
are
have
they?
to
I have
tell you,
no idea.
I'm having trouble connecting. I'm not sure if like to the USPTO.gov site for whatever reason. I'm not.
Yeah.
I don't know if because of weather something's gone down or if it's just my system. So I can't look them up. But I do know that you're absolutely right. There are I think it's 3 different categories. So if you were a regular inventor, it's X. If you're like a bigger company, and then there's a medium one, and then for micro entities, which are like the smaller inventors, like let's say you've just got something in your garage that you've been cooking up. And you're a small business, you might qualify for a micro entity status, and that's going to be, I mean, just not much money at all for filing the patent, which obviously is going to be different. If the patent attorney fees when you hire someone, that obviously, as Phyllis said, could be a whole lot more money. So I'll see if I can get the website working, and I'll see if I can find those fees for you with regard to patents. But with regard to trademarks. It's a little bit, I mean, sometimes people say, all right, Jason, how much is it going to cost me to get my trademark? Okay, well, there's no really good answer to that. And one thing to think about is that there are, well, you're really asking 2 different questions. How much does it cost to file your initial application? And how much might it cost you over the life of your trademark registration to sort of keep it alive? Because once you do register your trademark, you're not done. There's other things you have to do to make sure your registration is kept alive. So with regard to the filing fee to file your initial application, the cheapest is $250. That price can go up a little bit depending on the number of what are called international classes of goods and services you include in your application. Listen, clothing is in one class, software is in another class. So let's say you wanted to protect your trademark for both t-shirts and for software, downloadable software, then that would be 2 classes. So that's $500 for your original application. That's using what is known as the T's plus application. That's the lowest. The T standard is 350, so it kind of goes up, things like that. But cheapest, $250. But that also depends on what your filing basis is. So if you are someone who is already using your trademark in interstate commerce and you file under what's known as the use in commerce basis, then you're just going to pay $250 and your application is going to go through, and then you might have more fees later on down the road. If you are not yet using your trademark in interstate commerce, but you have a bona fide intent to do so within the next 3 to 4 years, you could file under a different filing basis, which is known as the Section 1B intent to use basis. Then, yeah, you might pay the $250 up front, but in order to actually register your mark, you have to amend your application to a use basis. And when you do that, that is going to cost you money. It's going to be $100 per class. If you have to file up to 5 extensions because you're not ready yet, that's $125 per extension request, right? So there could be a couple more $100 that you're adding in as you go, right? And then after registration, once you register, there are set maintenance documents that you need to file in order to keep your registration alive. The first one is between the 5th and 6th years, and then again between the 9th and 10th, and then every 10 years thereafter. So how much it's going to cost you over a lifetime is kind of hard to calculate because you don't really know. It depends on how long you keep your trademark registration alive. That's kind of up to you. But when you think about it over the life of a business, so think about, Coca-Cola, which has been around since 18 whatever, right? They have been able to keep their trademark registrations alive. And so, if you think about how, Coca-Cola is probably worth billions of dollars, right? Their trademark's worth probably $1 billion, something along those lines. And they're paying every 10 years, they might be paying $425 to keep a particular registration alive. Hey, that's not too bad, right? When you think about it, when you think about sort of like figuring out how much is it costing you per year over the life of your trademark and your trademark registration. So not too bad. But obviously, if you're just starting out, yeah, sure, $250 could be a lot of money. But over a lifetime, I think you're probably gonna, in the end, you're gonna gain more than you would lose.
Okay, thank you, Jason and Phyllis, for not shying away from those questions. And I just also want to mention that to all of our registrants and attendees today, we can also, in our follow-up email to you, share some of the resources that have been mentioned here, a ton from the USPTO. We have a lot of Michelson IP resources to share and other recommended links, so we can share those afterwards. And Leah, I'll turn it to you for our next question.
Awesome. I kind of wanted to change gears a little bit. We got two kind of similar questions submitted. So how might we as higher education instructors and teachers and professors really be influencers and motivators of these IP skills for students? So, you know, how can instructors really make this relevant and important to their students and really show the value of IP?
Wow. There are so many ways to do that, but I think the one or two that I would focus on if I were an educator is reaching out again to entities that exist. For example, the Michelson, right? Also, the Intellectual Property Owners Association has toolkits for teachers to, you know, teach segments on intellectual property. The USPTO, once again, has I'll call them ambassadors. I don't know what the official name is. The official name, but has programs by which folks who are knowledgeable, who are from the patent office, go into community organizations, schools, and various others and talk about intellectual property and the different types, you know, copyright, trademark, patent, and then trade secret. Leverage those, you know, we're taxpayer. If you're in the United States, you're a taxpayer. Leverage these facilities because they are available. And I think so many times they do not get utilized. Even the Girl Scouts has an IP patch program where you learn about invention and do some activity to develop that IP patch. So there are a lot of resources in your own community. Reach out. I'm on the board of the IPO Education Foundation, which is focused on, you know, educating the public about the importance of IP. And, you know, if you were to dial us up, call us up and say, gosh, I'm a professor or teacher in XYZ place, we would find someone to come and talk to your class about intellectual property and how it might relate to the work that they're doing then or they might do in the future.
Yeah, there are lots of great resources. I put in the chat there a link to, it's a little short link to uspto.gov/education. And for whatever reason, at least on my system, the website isn't working, but that should take you to where you want to go. We have a great education team and, you know, they often show up at trade shows and things like that, in addition to, you know, well, used to be in classroom types of things, but some really great resources, mainly focused to kids and teens, not necessarily for college students, but you know, there's lots of good stuff there. So that would be one. And you know, one thing I might think about is like using some of the, as a teacher, maybe using some of the basic information that you get from Michelson Foundation or from our website or for wherever it happens to be, is maybe create a project where you have your students invent, you know, quote unquote, invent a new thing, and then think about what are the intellectual property considerations that you might have. Like, so let's say you've invented that new type of vacuum cleaner. What would you do to protect, you know, the technology? Well, you might, you know, apply for a patent. What would you do about trying to protect the brand name? Well, you might register a trademark. What about the advertising jingle or the funny video that you come up with or the owner's manual? Well, you might register a copyright. So there might be ways to do like a practical sort of workshop with the students saying, blue sky this thing, you've just invented teleportation. Okay, so what are you going to do to protect your new device that allows you to teleport around the country? And so we no longer need cars and trucks and things like that. So what would that look like? You know, that sort of thing. So that might be a fun way to sort of talk about some of the concepts and see how they all interconnect and interrelate.
Awesome. Thank you so much. Johnny, I'll turn it back over to you.
Okay, great. And I'll also just mention that in addition to the Michelson curriculum and our textbook and all that, we also have a group of educators, our IP educators and residents, who are a fantastic group that are working to create broader IP literacy among the NACCE community. And I know I see we have at least one of them on today, who is Diane Sabato from Springfield Technical Community College. But reach out to them, reach out to us, and we can put you in touch with them because they have great ideas about how to really engage students around the topic of IP and across disciplines. So whether it's business and entrepreneurship, whether it's history, even engineering, really across disciplines, marketing. So please reach out, and it's just a great group to learn from. So let's go to a new question. Let's see, what is a patent agent?
That's a quick one. So I mentioned before that as an attorney, I have a registration number that I received when I took what we call the patent bar exam when I first began practicing. You don't have to be a lawyer to sit for that exam. You can be a person who is technically trained, and the office, the USPTO, has specific criteria for that under that educational training. I would not have been able to sit, regardless of being a lawyer, I would not have been able to sit for the patent bar, but for the fact that I have a degree in chemical engineering. That's what the cost of entry to be able to sit for the exam is, that you meet the educational requirements of either having a degree in mathematics, engineering, pure science, physics, and there's a few others, and then certain credit hours. And once you meet those criteria, you can sit for the exam and you get a registration number. If you are not a lawyer, if you do not also have a law degree, and you successfully pass the exam and you obtain a registration number, you are then a patent agent, which allows you to represent clients before the U.S. Patent and Trademark Office, but only before the USPTO, not like in Article 3 court or anything like that. So that's what a patent agent is. It's a technically trained person who's passed the exam.
I'll jump to the next question then. Thank you, Phyllis.
Mm-hmm.
This one's for all our educators on the line that use Canvas LMS. So one of the questions was, do I own the content that I have created in Canvas? And can administration give it to another instructor without my permission?
Well, without giving legal advice, I will say it depends. One of the things that as any employee and employer, in any employee and employer relationship, at least in the United States, you can privately order who owns what in terms of things that you generate in the process, materials that you might generate in the process of developing a curriculum, so forth and so on. So it really does depend on what, that agreement you signed way back when you went to work for the university or the other or whatever entity, and what the rules of the game are.
Yeah, I would agree with that. I'm going to try and type this in here real quick. Yeah, I think I got that right. So what we're really talking about is whether or not what you're creating is work for hire. And again, not legal advice. I'm not giving legal advice, but the phrase you'll often hear is whether the material was created under the work for hire doctrine. And what I just put into the chat there is a link to the PDF that's put out by the Copyright Office, which specifically addresses work for hire. So if it is something that is done in the course of your employment, then, and that's what Phyllis is talking about, like, what does the contract say? Are you employed when you're creating this thing? Then the owner of the information could be the person who hired you because you created it as an employee. If you create it outside, then that could be different. So check out that circular. It's really just a PDF. They just call them circulars, and that can give you some more specific information on work for hire.
Perfect, thank you. Johnny, I'll turn it back to you.
Okay, great. And yes, everything in this webinar is for educational purposes only. This is a learning community. Awesome. Question here, are there any specific things to consider when protecting a product composition formula in an early stage startup? Any things?
I think you always have to think about protecting your, whatever your secret sauce might be. There are lots of ways to protect things outside of inventions and innovations, outside of the patent system. For example, I'm sure everyone on this call has heard that the formula for Coca-Cola is not patented. It is held as a trade secret. And because it is held as a trade secret, as long as they keep it secret and they take reasonable precautions to keep it secret, then they will have the rights in that until, you know, infinitely, right? Until infinity. A patent has a limited time, is limited in time. So filing a patent application, so you must teach the public how to make and use the invention, you get a limited monopoly, right? You get the right to exclude for a certain period of time. And many folks, and many things, particularly in the startup universe, go from being held as trade secrets to ultimately being patented. Now, it just so happens that when you really talk about ingredients, so I put this with that, the other, ingredients, largely not patentable under most circumstances, right? For a lot of arcane patent reasons that I won't go into, but just take my word for it. And so it makes sense to hold ingredient type things as trade secrets, so long as they can't be detected by folks who have nefarious intent or intent to copy out there in the universe and can copy your product. But importantly, here's the other thing, value that Coke has, and this ties into what Todd talked about. I would venture to say that it probably doesn't take a nuclear scientist to figure out the formulation of Coke. The problem is whoever figures it out can't use the name Coca-Cola with it. That's the problem. So that's why they would not be successful. So making sure you have a strong brand and a strong product are the things that create the secret sauce for you to have a strong place in the marketplace, you know, into perpetuity.
So I'll ask you this question, Phyllis. What about things like provisional patents and, you know, and being careful not to disclose the information to people who could, based upon the information, know how to make the thing? Right. Do you have any thoughts on that?
Well, provisional patents, and I'll just give a quick primer on that. A provisional patent is kind of like a pre-patent. Let's call it a pre-patent. It's something you file before you file your full utility patent, and it doesn't give you any rights to exclude, but what it does is it gives you a date by which you can prove that you had the invention, at least that date, right? So if I filed a provisional patent today, which is what, the 18th, so what is today? 18th of February in 2021, I have until the 18th of February of 2022 to file a full utility patent based upon and claim priority to claim this date as my priority date on that patent application. Those can be a great tool because they're cheap. All you have to do is draft your provisional patent application, and there really isn't any instruction. There are very limited instructions as to what it has to contain. Put a cover sheet on it, pay $100 or whatever it is, and send it to the office, and then you have proof I have this invention. And then in a year, within a year, I need to file my full utility. The only watch out there is that what typically happens in that year is you invent a lot of other stuff that go along with the provisional. And so you're actually going to file a whole different patent application when it comes around to time to file your patent application claiming to the provisional date. And you will only get that early date as to the stuff you had on February 18th of 2021. That you only get that date for the stuff you had then. Anything you added in the interim, you'll get that new filing date for. So it's complicated. I think provisionals are good because they're not published. Nobody will know you. If you never file a utility application claiming priority to the provisional, nobody will ever know what's in the provisional. So if you decided, oh, I still want to maintain that, I think I should maintain it as a trade secret, you still have that opportunity, because that's not going to become public. And it also buys you some time to do some development so that you can file that non-provisional application.
Cool. Thanks. It's one of the things I've always kind of wondered about. So thanks.
Alrighty, I'll jump in here for the next question. I think this is a popular one, at least I've heard our IP educators and residents have said their students have asked this a lot, is how do we protect a domain name if it's the name as our business name? It was the same as our business name, excuse me.
Oh, great question. All right. So I'm hearing 3 different things in there. I'm hearing business name, I'm hearing domain name, and I'm hearing trademark. Okay. So let me sort of dispense with domain names and business names at the same time. So domain name, obviously we know what that is. That's just the web address, right? A business name, sometimes called a company name, or a trade name. Sometimes people talk about them as a DBA or AKA, stuff like that, right? So a business name or a trade name is just the name that you use and that you file with usually your state in order to do business in that state. All right. So it could be like, for example, Google, their company name is, Alphabet, right? It's no longer Google, it's Alphabet, right? So they file that name in order to do business under that name. Cool, that's totally fine. Your domain name and your business name can be completely different than your trademark. So your trademark can be your brand, your slogan, your logo, whatever it happens to be. Oftentimes they're completely separate, but they don't have to be. There are circumstances where your domain name, where your business name can be the exact same thing as your trademark, and that's totally fine. It all depends though on how you use it. So in order to register with the USPTO, what you use as your domain name or what you use as your business name, your company name, your trade name, to register those things as a trademark, you have to be using it as a trademark. So think about any website, right? Or let's do this. Think about 10 years ago, 15 years ago, Amazon.com, right? Amazon.com is how you find something online. You would type it into the search bar or into the URL, thing, and there it's being used as a domain name. But on that exact same page where you could buy your books and your automobile tires and your diapers and your coffins and your bulk whatever, right? It also shown as a brand name on the website was Amazon.com, not in the little bar at the top, but on the page itself. So that is being used in that case as a trademark. So if your domain name, you're using your domain name as a trademark, or if you're using your business name as a trademark, that's totally fine. If you want to protect it as through a trademark registration, that's okay. You just have to show us in the evidence that you submit with your application. The evidence is called a specimen. You have to submit a specimen that shows your trademark, well, your domain name or your business name being used as a trademark. And that's totally fine.
Yeah, I would also say, having been the chief IP counsel at Starbucks. So Starbucks is a trademark, right? We have a domain name, starbucks.com. Because we have a trademark in Starbucks, we have the ability to go through ICANN and get anybody who is utilizing starbucks.com improperly, get it taken down. And that's because we have a trademark on Starbucks. We have trademark rights in Starbucks, and we can leverage those as a takedown for starbucks.com. So that's slightly different, but it does evidence sort of the importance of having that trademark protection for your name in that case, because you can leverage it against other infringing domains.
Yeah, it's like the reverse side of it. So instead of registering the domain name as a trademark, you're using the trademark to protect your domain name from cyber squatters and things like that. Yeah. That's not really much of a thing anymore, but was a long time ago. So that's fascinating.
Still happens a lot. A lot. They don't call it cyber squatting, but it happens a lot.
Thank you so much to Jason and Phyllis for sharing their time and expertise today. I feel like I just learned so much just sitting here and listening to you all, and really appreciate your guys' time. And thank you to all of our attendees and our listeners, both those live and those listening to the recording, for submitting their questions and participating in this call as well too. So we'd ask that you would just take our brief survey. It's 3 questions after you exit the webinar, and would encourage you all to check out all the resources that were referenced today, and especially from our partner, Michelson IP. So that being said, this webinar is now complete. Have a great rest of your afternoon and stay safe, everyone. Thanks so much.
Thank you.
Thank you.
Thank you.